schedule. We're going to start off with you, Mr. Dixon, and pick up where we left off. You have some matters you want to take up first?
Yes, thank you, Commissioner.
There are a couple of things too, but we'll go with you first, and then we'll deal with housekeeping.
Okay. So I've got a list of about 8 matters to run through from yesterday. I'll deal with the one that Ms. Appleyard is here to hear first. At the close of the hearing yesterday, she and I had a discussion about the client's interest in there being decisions as soon as reasonably possible in relation to Antonio Hall and Dewsbury. And I've had a discussion and have instructions from the council district plan unit. And those instructions I'll pass on to you that they would appreciate if you are able to issue a decision on Antonio Hall and Dewsbury in advance of the rest of your decision, if it doesn't slow up the rest of the decision.
Okay. Well, the reality is it won't be within the next month. Whether it could be sooner than the month that follows, which is the target date of the 20th of August. I mean, I can't make any assurances around that, but taking on board what you're asking.
Yes.
Maybe we've had the opportunity. Our intention is to, assuming we conclude the hearing time, either today or early tomorrow, that we have ourselves as a panel an opportunity to not only initiate deliberation, but also get our house in order, if I can put it that way. So it might be that's an opportune time that we can give some sense of whether that's a reality or not. Sure. If that suits your purposes.
Yes.
Here where you're coming from, equally.
And it's just a request.
Yeah, sure.
If you can, you can.
Yeah.
Can't. But
what I can say is it won't be within a month. Won't be a month.
We understood that. Yeah. Because there's also the issue of site visits. If you, that aren't going to happen, obviously.
No, they would happen after. And if we are going to do those, and we will, we'll want to do that before we make any decisions, obviously. So, all right, take that on board, and we'll give you a heads up before the end of the week as to what our thinking is. If that suits.
Okay.
All right.
And while Ms. Appleyard is here, I'll move on to a couple of the other points that I wanted to touch on first thing this morning. First one is Ms. Appleyard's submission. I could have saved this to the right of reply, but I'll say it now while she's here. Ms. Appleyard's submission that you should basically ignore the evidence being led by the council in relation to Antonio Hall and Dewsbury, because the council position is different. That is not, in my submission, appropriate. It is wholly appropriate for the council to lead evidence from neutral independent experts to assist you in your decision making, even though the council position might be different. So that's my response to her primary submission point yesterday. And secondly, I certainly don't want to get into a he said, she said with my learned friend, but there was one paragraph in Ms. Appleyard's submissions that I would like to comment on, and that was paragraph 28, in which she was referring to her, in Ms. Appleyard's words, she signalled to Mr. Busy last week that I would be bringing these witnesses just to update their numbers. And yes, she did indicate to me last week that she was considering bringing valuation evidence, but I didn't indicate any position on the council on either support or opposition to that. And that was certainly not me making a decision for you on the appropriateness of doing that.
I can confirm what Mr. Pizzi just said. It wasn't intended to be anything more than that. I had signalled I'd be updating evidence. And so I'm happy with the way Mr. Pizzi's explained it.
Yeah, and as we said yesterday, like we gave you a bit of licence yesterday, and some of that is driven by the circumstances beyond anyone's control around timing of the decision.
And when I had the discussion with Mr. Pizzi, I actually didn't have any of that evidence. If you actually look at it, most of it's dated yesterday, so I didn't actually have it at that time.
Now, having said that, we're still yet to consider whether there's any prejudicial consequence as a result of what happened yesterday. I mean, our call on the day was to hear it, so that at least we had that advantage. And if we later decide that we don't want to use it or can't or shouldn't, then that will subsequently follow. But at least we've now got the benefit of having that in front of us.
Yeah. Thank you.
Thank you. Thanks, Brent.
Next point I wanted to touch on was Mr. Evan Stanley, the quantity surveyor.
Yes.
was watching when the evidence was presented yesterday, and passed on to him the table that the quantity surveyor for Daresbury presented. He's looked at it. He's said that he doesn't have any significant issues with what he sees in that. It hasn't changed the bottom line, if I can paraphrase, that there's something like a 3 to 4% difference in the bottom line between those two experts.
Okay, that's helpful because we had just ourselves decided or talking about whether we might bring Mr. Stanley back to ask him that very question. Is he available today?
Yeah, he is.
Yeah, should we change our view on that? Okay, probably at this stage, given that response, I don't know, we probably don't need to hear from him.
It may be helpful if he could.
Sure. Yeah. Yeah.
And if our view changes, we'll come back to you. The only other, while we're talking return visits, this Richmond might be the only other at this stage council on this that we might want to revisit, if you like.
Possibly one other commissioner, Dr. McEwen, has said to me this morning that she has visited the sites, or at least considered the sites, actually visited the sites that were raised by Commissioner yesterday with some questions about ratings. So she could give some further.
Those properties that you raised, Commissioner.
So you have a position on that? Okay. Well, let's keep that you around today. Yeah. Let's find a slot if that emerges. My concern today is that we may find ourselves very much behind time, and the reality might be that we spill it till tomorrow. Might be wrong, but it looks like an optimistic lineup to me. So whether there's a convenient moment through the course of today to just have you present that. How long will that take? A few minutes? Yeah. Okay. Let's just.
At your convenience.
Yeah, let's do that. Worst case scenario is you can put a brief statement to us in writing as to what those responses are.
Okay. Next, some miscellaneous matters from yesterday that it's worth covering off today. There was a question raised in the evidence led by Ms. yesterday about whether Amanda Rose had taken a March 2024 fire into account.
February, March 24.
Yeah. In relation to Antonio Hall.
This is the third fire.
And the answer was yes.
Yeah. You had.
Yeah. Next, getting down to two miscellaneous matters now. There was a question yesterday about what is batch 86.
68.
68.
We've got a graphic which now shows us that.
Graphic that shows it now. And the last one, question from yesterday, Commissioner Caldwell, I think it was, are cemeteries reserves? Some are, some aren't. Sydenham isn't.
Sydenham isn't.
Sydenham isn't. Yeah. Thank you.
Thank you. All right.
I'm gonna find out what. Can you get my bag because I didn't get it out yet?
Your hands full of.
Yeah.
I don't know if you can hear me. Is it Gina Robson?
Chocolate chops and stuff.
Gina, can you hear me? don't know where.
Mum, come here.
Is that IT guy here?
Yeah, I think so. He's somewhere down West Point.
Yeah.
Can anybody who's watching, please make sure that your microphones are off? Oh, thank you, Ms. Robson, you've just turned yours off, so thank you.
Yeah, thank you. It's just coming through into the room, obviously, it's annoying. All right. We've got your summary statement, not the legal submission. We all have it. You take us through that.
Name is Glenda, Dixon, professional experience regarding my evidence in chief. I summarise key points in my evidence here, respond to some of Dr. Bruce Harding's statements on the Lake Village Residential Heritage area, and respond to the evidence of Tim Joll for the Canterbury Rugby Football Union. I've been asked by the council to provide evidence on the planning context of residential heritage areas and the proposed policies and rules for residential heritage areas. I addressed these matters and submissions and further submissions on these matters in my Section 42A report. I reaffirm that I'm complying with the Environment Court's Code of Conduct for expert witnesses. In Part 6 of my Section 42A planning assessment, I provide an overview of the development of the proposed RHAs under PC13. RHAs aim to protect areas which have collective heritage values as distinctive and significant residential environments. During the assessment and mapping of the proposed RHAs, I liaised extensively with Dr. McEwen, the Council's heritage consultant. I rely on her evidence to this hearing to make recommendations on the identification of individual RHAs, assessment of properties within them, and the potential for additional RHAs. In parts 8 to 14 of my Section 42A assessment, I addressed particular issues raised by submitters and further submitters in relation to the planning provisions proposed for these areas, and I add further discussion on more general issues which have become evident through administration of provisions since notification in 2023. Live issues raised by submitters and discussed in my evidence are, as Mr. Pizzi outlined to you yesterday, there are one or two issues which are sort of split into multiple parts. Skip through that. The provisions as a result of the Council's withdrawals of parts of PC13 described in the Council's opening submissions. Only the core provisions for RHAs are left, with only a few references to RHAs elsewhere, for example, in the Chapter 9.3 policies. The core provisions are rules 93413, 86 and 87, which require a restricted discretionary activity resource consent for new buildings, alterations to exteriors, which are on Main Street. And in my evidence, I recommend that this only apply to defining and contributory buildings, and the demolition of defining and contributory buildings. D6 also requires consent for new and altered road boundary fences, which are or will be over 1.5 metres in height. There are proposed matters of discretion for both RD6 and RD7 at 9364 and 9365. In my evidence, I have suggested some minor amendments to these rules and matters of discretion. For example, the amendment noted above, just previously, and for matters of discretion to clarify that the focus of the RD consents is intended to be primarily on the area and only secondarily on the building. In my opinion, these four rules, as amended, are reasonable and justifiable and are the least restrictive provisions that could effectively implement the RHA concept. I cover the requirements of Section 77I and J of the RMA in regard to the two RHAs in policy 3 areas, Chester Street, Dawson Street RHA, and the Inner City West RHA, whereas 519 and 597 my evidence. The difference between RHAs and character areas. Appendix F to my evidence and paragraph 8.2 summarise the way that RHAs and character areas approach different types of heritage or character areas. RHAs have notable non-visual values, historical, social, cultural and spiritual, which character areas do not. So character areas are essentially visual. Although there may be some similarity between the two in terms of architectural and textual values, and historical lens is applied to these values of RHAs. Demolition policy and rules. I discussed those in section 10.3 of my evidence. There is a difference in consent status between demolition of a highly significant or significant building. In the operative plan, these are non-complying and discretionary activities respectively, and demolition of defining and contributory buildings in an RHA, which is proposed to be a restricted discretionary activity. It appears from submissions that people mistakenly assume that needing a consent for demolition in an RHA means that demolition will automatically be refused. In paragraphs 127 and 28, I note that there have been actually now 3 demolition consents approved, with only one of these being publicly notified and going to a hearing.
Sorry, what the third one is? We might go on to say that.
11 Gossip Street in the St Albans RHA.
Gossip Street, was it?
Yes, I think it was approved only a couple of weeks ago.
Okay.
Submitters have stated that in respect of the amended policy 93228 demolition of scheduled historic heritage, that it is inappropriate for buildings located within a heritage area to be subject to the same demolition policy test as listed heritage items. I.e., they effectively seek a clearer distinction in the policy between scheduled and unscheduled buildings. In my 42A report, I agree that this would be desirable and consider that this is appropriate to amend this policy to do this. My proposed wording at paragraph 10.37 includes strongly discouraged for demolition of defining buildings and discouraged for demolition of contributory buildings. Although the verb discourage is not standard RMA language, it is used in the district plan already in several places. Footnote there, I consider that discourage and strongly discourage express a clearer policy position as a guide to applicants than the way the current demolition policy for scheduled items is worded. This merely sets out the matters to which regard will be had and leaves decisions to be made by individual consents.
By current demolition policy for scheduled items, you're referring to operative or proposed?
Operative, without this, avoid where possible.
Yes, without that wording changes now come through.
Yes.
Or suggested to come through.
Yes, yes. So that would change my last couple of sentences. I agree with Mrs. Richmond's recommendation that the base demolition policy for scheduled heritage items should be amended to express a clearer policy position, such as avoid where possible. Doing this would create more of a hierarchy in the policy in which scheduled items or buildings are at the top of the hierarchy, and there is a distinction between defining and contributory buildings. Notification issues. Experience with processing RD consents in RHAs since 2023 has identified issues with whether or not applications for demolition will be notified. See my evidence on that matter. When considering demolition in an RHA, it's difficult to conclude that demolition has less than minor effects on the immediate environment. If the heritage advice is that there are minor or more than minor effects, and this advice is accepted by consent planners, then notification becomes much more likely. There are 1,112 properties in RHAs, with 691 of these in Littleton, and those are figures following taking out the 24 properties that Council recently resolved to exclude. Each RHA has a majority of defining and contributory buildings, which would apply a restricted discretionary consent to demolish. In my view, it's unreasonable to at least limited notify and possibly publicly notify nearly all demolition applications in RHAs. cost of resource consents goes up considerably with notification, as does the time taken to reach an outcome. In my view, for contributory buildings, it should be possible to reach an appropriate decision under Section 104, which still takes full account of heritage values, without involving neighbours or other external parties. By definition, contributory buildings are not those buildings which establish heritage values and significance in the area. I do not favour defining buildings having a non-notification rule, because they are the more significant buildings in the area and are likely to be of most interest to parties other than council. Some are actually scheduled as well within the RHAs, and scheduled buildings are not limited by non-notification rules. My Section 42A assessment therefore recommends that a non-notification rule be inserted for demolition of contributory buildings in RHAs.
What was the, I don't know if it landed on thresholds or whatever, in terms of quantity that needed to be defining?
Well, that was kind of a screening list for being an RHA at all, and then to be in planning terms, really for our sort of purposes, still in RHA, it was over 50% of the buildings being defining and contributory. So if there was significantly less than that, we probably would think that's actually not going to be appropriate to be an RHA.
Just thinking about the quantum that would have been otherwise exposed if we didn't accept your recommendation here to the notification possibility of potentially half of the buildings.
That's right. So in terms of the 1112, it obviously depends on how many proposals you get in each year, etc. But it is potentially quite a number that might put up proposals to demolish. I've mentioned in my evidence that we've had several re-education meetings, so there is interest on some behalf of some parties.
Yeah, I'm just trying to get a sense of scale, if you like, between what could be captured of all the total properties. This notification distinction.
Yeah, I do have a table which I can provide, which sets out all the proportions of each of the individual RHAs, but it needs a little bit of tidying up.
I might have mentioned it. Okay.
I can provide that if you like it.
Can you just tell me what happens with the replacement building for a contributory building? What is there a serious specific assessment as to how it fits with the replacement?
Yeah.
The new building will be contributory or negative or neutral or whatever.
New buildings for actually all of the categories are restricted discretionary activity, just in order to ensure that that's sympathetic.
Right. So the RD is, and that's a matter of discretion.
There are a number of matters of discretion, but yes.
I just ask you to, and I was going to save it to the end, but I'll talk about it. But that avoid where possible addition to the policy. Do you have any concerns in terms of well, there were two. I think there were two issues. One is in terms of certainty, how we determine what's possible, and the other is whether that makes the just starts to clarify whether that would impact on that would impact potentially on non-complying activities. Do you think in terms of
well, highly significant items are a non-complying activity to demolish anyway. I think I endorse what Suzanne said yesterday about the fact that there are often sort of circumstances that might be weighed in the balance of the decision for demolition. So I guess it's trying to express a reasonably clear position on behalf of council, but kind of allowing for the possibility of some of these other factors being present.
There's a bit of conversation yesterday about whether the gateways under 104D would actually be achievable, except that, you know, what might be considered to be a probability around the significance of effects, and leaving you the second gateway around contrary to, and whether, you know, it's notified or even is suggested to be changed, the wording might present a realistic impediment to that second gateway being passed, which will use.
I guess that is a matter of opinion. I feel that with assessment, processing plan is going to have a pretty clear idea of what those other issues are in terms of the matters of discretion. And, well, actually, for scheduled heritage items, I should point out there's a longer, different matters of discretion.
Sure.
So they will have a pretty clear idea of the circumstances and all of the issues that were raised yesterday in terms of the economic implications, the cost of potential costs of rebuild and things like that. So I don't think it's really going to be a bar to making that 104D decision.
Do you think that wording change helps in that? Yeah.
I think it probably is a bit clearer because at the moment, as I suggested before that, I didn't think that the existing items demolition policy was terribly clear as to what council's approach would be likely to be, and it would kind of fall to the consideration of circumstances. Whereas at least if we put that wording in, then it's a bit clearer that we are really not keen on demolition. Applicants will probably find that out anyway, but I think it's a little bit clearer on the face of the plan. And, you know, the fact that we're not 100% absolute.
So, since we're having a chat, you don't mind if we just in terms of the notification provisions, there was evidence expressed. Sorry, I just can't remember whose evidence it was, but about the benefits of being able of notification, if you like, being a tool which creates more engagement, if you like, because they get involved in discussing it before to do any. Does that fit in with what you're suggesting, where not notification?
I think probably the heritage team would prefer to have as many tools as possible. I guess I'm kind of weighing that up with the potential scale of applications and, in my view, what's reasonable or not. That might not 100% match what the heritage team would want. I'm kind of looking at it from the strictly planning point of view.
That's good. That's what we're asking you to do.
Appreciate that.
Sorry, right.
Bottom of that page, paragraph 19, amendments to evidence, is a sentence in my evidence that it's incorrect that I'd like to strike out in terms of the zoning as HR said and what it allows for. That becomes important for the Chester Street residents. Okay.
So take us to the, we're talking 12.1.2, am I right?
Yeah, 12.1.2 is to do with zoning situation around RHAs, which actually, strictly speaking, as Brent said yesterday, is already decided, so it's not something that you guys
Yes.
have got into. It's page 75, I think.
Yes, just the last bit of the last sentences.
The sentence just before the last sentence that talks about 20 metres, and so that should be 22 metres or around 6 stories. And that's the situation as well for the western end of Chester Street East as a result of the PC14 decisions. So that western end is a bit of a carve out from the surrounding central city residential precinct that has a 39 metre height permissible for around 12 stories. So I had that wrong.
I'll check that last sentence.
Yes. Paragraph 20 is another place in my evidence where I made a similar error, which I'd like to replace the maximum height of 32 metres, 10 stories, with a maximum height of 49 metres or 12. That's on page 14.
Out of 12.
Other changes, yeah.
Yeah.
All right.
So it's on Dr. Harding's evidence. Dr. Harding has confused essential characteristics and got to specific and the proposed heritage areas in page 13. The next on page PC 13 web page. I provided a link there. Show the two areas in comparison to each other, and they're quite different because they are delineated on different factors or attributes. I have, as I've mentioned, discussed the difference between RHAs and character areas in my evidence. The origin character area does include the commercially village green. The character area extends to the south of the map, even in my maps for the hearing. In terms of looking at the whole of it, you can look at the property search function of the district plan maps and click on other notations. I described Council's consultation at the draft stage of PC 13 and 14, and that linked to the PC 14 document. That was an issue for the PC 14 hearing. Mr. Joll's planning evidence for the RFU. Joll's evidence regarding Rugby Park and the Church Property Trustees Lawson Buildings RHA contains some notable inaccuracies, and there are a number of statements I disagree with. Firstly, in his paragraphs 34 to 36 and 39, he suggests problems with the notified version of the PC 13 policy wording, and he suggests they are inaccurate. The notified provisions of PC 13 are to be found under the provisions subtitle. These provisions show that the definition of heritage values is proposed to be modified by the insertion of the words heritage area. That changes the definition, makes the references to heritage values appropriate in policy 93222 and in the matters of discretion. The amended policy 93225 on ongoing use already references defining and contributory buildings.
So that insertion of heritage, creates that link and consistency through that policy.
Yes. Secondly, Mr. Joll states in paragraph 32 that the IHP for PC 14 dismissed the section 32 report for heritage as not being robust. That panel was not in fact referring to the current PC 13 section 32 report, since they had decided they had no mandate to refer to that. We were referring instead to a separate PC 14 section 32 report covering a number of qualified matters briefly. I agree that the PC 13 section 32 report does not include any reference to the costs and benefits of including large open spaces. This is primarily because I considered it to be valid to include these spaces in RHAs based on advice from Dr. Cohen. Until the recent council decision withdrawing the Pico Shand and Beacon Street RHAs, from PC 13, the plan change to other RHAs with large open spaces at the beginning. Park on in Elmwood Park. These in the RHA. And there are a number of smaller open spaces, for example, the Cashmere Village Green. That's in the, no, I don't know if it is actually in the RHA, I'd have to check that.
The Millen, the green.
Yeah. No, possibly it's
The character of it.
okay, that's not in the RHA.
RHA, yeah.
There's definitely some more smaller open spaces around the place, like in the Littleton RHA that are included.
Street East.
Jesus Street East includes the
And Inglefield A.
East. The terminology used in the core 86 and 87 rules is buildings, not residential units. This was deliberate in order to allow for non-residential buildings in some RHAs. For example, there was a Plunkett Rooms building in the Pico Shand RHA, and there's a church in the North St Albans RHA. There was no major disadvantage to residential properties from being included in the RHAs, and this is especially the case since the withdrawal by Council of the area-specific built form rules for RHAs. On a restricted discretionary application, the built form rules of the zoning of the property, in terms of Rugby Park, open space metropolitan zone, will be a starting point or guide, but they're not binding. Rugby Park has a specific 8 metres height limit for new buildings and a 10% site coverage rule, which already limit what can be done even without the assistance of an RHA. So it is possible that consents could be required anyway, with heritage values simply being another factor in the mix.
The development of Rugby Park's pushing those boundaries in terms of, I don't know about height limit, but in terms of coverage.
I wondered about that, and I checked that the site coverage rule and open space zone didn't include impervious surfaces, because they've certainly got a very large area of paving for the new park, and it doesn't. It's only buildings. It's hard to tell. I haven't done a complete check, but it looks like it could be up there because of new offices, I think, on the southern corner.
That may be something Mr. Joll could respond to.
Yes. Except that I omitted to mention control over demolition in the RHA in my evidence in relation to the CRFU further submissions. That was incomprehensive. I do not agree with Mr. Joll that there is a high bar created by the words whether options for retention and repair have been thoroughly considered and have been shown to be feasible or otherwise in a proposed policy. If the building itself has little merit, for example, then it is likely that the effects of demolition of it would be assessed as being less than minor. This was a situation with the lunchroom and tuck shop on the old Girls High site at 32 Armagh Street. The effects were assessed as being less than minor. It was granted a demolition consent by council in 2023. I'm not sure how Mr. Joll arrives at the view that fencing outcomes for the RHA are focused on low-rise picket fencing and pool fencing. Dr. McEwen's heritage report and the Section 32 report, that's for obviously the North St Albans area specifically. She says low and medium height hedging, boundary walls, fences are generally in sympathy with the character of the houses. So it's kind of a description of the heritage values in the area rather than any prescriptive rule. Differences here. Grounds evidence. Just a couple of things to say there. That's yesterday. This infused Appendix 10 to my PC 13 Section 32, which is a template for screening RHAs, with Appendix F to my current Section 42A evidence. These things do get quite confusing. So my Appendix F is identifying criteria for RHAs with those for character areas. And it's not a review checklist. The statements at the top are my own, these are summary statements. They were used to provide a convenient summary of the differences between the two types of areas to persons unfamiliar with the two concepts. There are two typographical errors in paragraph 8.2 in relation to those statements. So, summary statements were some areas have no coherent history.
Just a second. That's what led that one of these here have in front of me.
That'll be obvious. So I into typos.
Questions? Just finding their feet. I'll just start with when I read through your primary statement of evidence. There was, I think, very near the beginning, your statement around you being satisfied of that scope. Subsequently, throughout there's various areas where the issue of scope potentially arises. I'm not going to, when I read it, I identified all of those, but in the context of what we discussed yesterday, Mr. President, I'm sure he's got to come back with that. He's already done some of his open submissions around some guidance on those matters. I'm not going to take you through each of them, but you were listening to yesterday. Was there anything that came up in the discussion yesterday, and particularly the submissions from Mr. Pizzi around scope matters, that give you any reason to change what you've said?
No, I was already aware that the Barbados Street situation was potentially out of scope, because of course it wasn't part of our notified boundaries, and I agree with the comments you made about the inner city west. It's usually within scope to shrink boundaries.
Yes.
What was the other one? There was the Ryan Street one. Obviously, we haven't got any mandate to. It is an RHA at the moment. We don't have any work on it either, as far as I know. Any significant work.
Yeah, I can't call off topic where there are others, but my question was really if there's a point of difference from your perspective of what we heard yesterday, that I hear it's not. Okay. I'll take you to page 35 of your primary evidence. Would have heard me have some conversations yesterday regarding the feed site, just reduce the bicycle site, and your perspectives on the importance or significance of retaining some delineation, if you like, around how the boundaries of that RHA apply to that property, either the property in full or reduced frontage, if I can put it that way, or potentially not at all, which might create, at least on mapping terms, a need. What's your perspective on that?
I think Fienn's in a submission opposing it, that site being in the RHA at all. And we looked at various options, we as in me and Anne, as part of doing a site visit one day. By that stage, I was aware that Fiends had put in a kind of indicative drawing of what we might want to do on the southern half of the site, which from memory was about additional office buildings. And obviously they are not tied by that development indication, but as Anne said yesterday, it's pretty unlikely that there will be any fire engines coming out of that access onto Chester Street. And they have Fiends indicated that they're only talking about single-storey buildings. So it seemed to me that it was quite possible that they would want to keep that landscaping because they've got a fence that's, I don't know how many metres in at the minute. There's a few. And in terms of contextual values, particularly for heritage areas, vegetation is a contribution to that. So I do think it's actually worthwhile for us to include that strip, and it also has the benefit of connecting better with the properties to the west that we were talking about yesterday.
I've been in engagement with the fire service in relation to your recommendation, given the original submission.
I think so, because do you remember we talked about that? We've been back and forth several times.
I think things went quiet.
Yeah, I mean, obviously it was a case of if we're going to pull the boundary south, where do we draw the boundary? And there's a title boundary that's quite a bit further into the site, but that was potentially going to go through in the future and things like that. So I think they probably didn't like that.
Yeah.
So I'm not sure if we had a final discussion, as you say.
Okay. Just last question on that in relation to the status of that vegetation. Assuming the RHA is defined as you propose with a 5 metre shrub. What's the status of that vegetation if it was to be removed? And what's the status of new buildings within that 5 metre strip?
Well, as I've noted at the end of paragraph 817, obviously the vegetation is not protected, so it would be possible to remove it without any council assessment. But if future buildings were to be located smack up against the road boundary or within the 1.5 metres of then obviously that would trigger a consent, but close to the 1.5 metres of the HRZ, yeah, if we have 5 metres, that would trigger resource consent under the RHA.
RHA, but no other provision of the plan would be.
Not that I'm aware of, no.
That is really where I searched it, sort of
Yes.
Yeah. Okay. One for flight. You may have touched on it just previously when we were talking about Rugby Park and coverage and the height restrictions. Are they the only, setting aside the possibility of RHA, are they the only restraint on development of those two provisions, height?
No, there are some other rules which I thought were of lesser likelihood of triggering consents. Remember more.
Don't worry, I can find it.
There are a few other building rules.
It's not solely limited to site and coverage, aren't the only controlling factors. Yeah. Page 74, paragraph 11, 5.5. on page 74. You're talking there about clarification in relation to temporary buildings within heritage areas. It's the topic. If we're back at Chester Street, sorry, I should have asked this in some.
That's all right.
If the definition of the boundary or the boundary definition stays as proposed, what's the consequence of that for the types of activities that the site currently has? So rather than a redevelopment for residential or office, where does that land the ongoing activities of the fire service? If it's wholly within the RHA.
Well, I mean, as I think I've said, the base zoning is HRZ up there, so it's
It could be out of those essentially.
in fact, I believe that site was originally residential back in the 1960s or something like that. It got a resource consent to be located there.
So it's there by way of consent.
I think so.
Okay. So it would fall back to it hasn't got any special acknowledgement beyond the underlying zoning and the entitlement through a consent historically.
I don't think it's actually designated either.
That's sort of where I'm going, I guess, is scheduled or some other uniqueness.
No, I haven't actually spotted anything like that. I'll check more carefully, but
No, that's fine.
it doesn't seem to have indication on the planning maps.
Yeah, I'm just trying to give a comprehensive picture of line or other possibilities of where that lands the activity, wherever that boundary may fall. That is all from me.
Can I just add to that and then go backwards? Because there might not be a designation for that site, for the fence site. There is the possibility theoretically that fence will sell that site and go somewhere else, as they have done lately with a lot of their sites that are in close proximity to the inner city. How would that affect if they sell the sites? I understand it's, there's one site involved. Yeah. The 5 meter strip then, how will that affect any person that is not a fire service but somebody who wants to build a normal house there?
Well, I think it'd be beneficial in the sense that it's a buffer to the rest of the surrounds of that site and the residential nature of that. I mean, clearly under HRC, you could have residential development there again.
Okay. Regards to include buildings in the schedule, that they'd have a consent for demolition
In the individual items schedule.
in the individual item schedule. Actually, it's even in the RHA. If you include, and that's the example of Christ College. Christ College have a COC for the demolition of their buildings, and as far as I understand, Dr. McEwen said, but they should still be in there, even though they could be taken out if they wanted to, because they are already contributing or still contributing to it. What's the difference in your view from a planning perspective? If they are in or out, does that make a difference?
They contribute hugely to the heritage values in that area.
But they will do that as long as they are there anyway.
Yes, that's right.
So, and that in that respect, if they are there and they are not included in the RHA, they are still contributing.
Right. I guess
It's a matter of then, I guess, later on, if they are demolished, to reduce the RHA, and that
yes, that's right.
will our plan change.
That's right. And time, it gives us a little bit of an input in regard to any development proposals. For example, they've got some very large, what appear to be residential buildings, but are actually used for school purposes. And it could be that they want to develop one or more of those sites. For example, amalgamate three of those, because the ownership is mostly contiguous. It's not completely, but
Yeah, so I understand it's more about the control of what replaces any buildings if they would be demolished, rather than the tension of those buildings within.
yeah, I think probably what would happen is you would devalue the RHA by taking those buildings out, because a lot of Christ College buildings are fine. And, according to the planning criteria of more than 50% of the area should be defining and contributory, you'd be getting quite close to that, the limitation.
So that was just my next question, how much impact would that have, and would that still then be an RHA?
Yes, it would. I worked that out. PC 14. As I said, I do have a table somewhere of that, but existing, but it could really devalue that area.
That's on the basis of the Christ College exercising its certificates.
Yes,
Knowledge.
yes.
Yeah.
As you probably noticed, what happened is we put a draft of this plan change up quite some time before it was actually finally notified. So there's an opportunity for applications for compliance, etc. And I understood from Christ College that they don't actually have any intention of demolishing everything. But yeah, that is a totally legal thing to do.
That there is, with regards to rule 9364, that's page 63 of your evidence in chief, page 10.2.2. We split out the primary value and the secondary heritage value of the individual buildings within the area. We compare that on page 66, matters of discretion. Can you explain to me what the difference is in terms of the heritage values that you try to protect? It seems to me that in 9.3.6.5b, whether the building is a defining building or a contributory building, as the specific contribution the building makes to the significance of the area. So that has nothing to do with the heritage values of the building as such, but it has to do with the actual value that the building contributes to the area. Is that how I understand it?
I think the first part of that B, whether the building is primary or relates to the fact that those are the only two categories that we have control over: demolition or proposing demolition control over. And I don't know that that was terribly well articulated in our notified version, because I guess that words that would have been added to improve that. So the specific contribution the building makes is actually obviously a consideration in terms of demolition, and I've talked a bit about that elsewhere. But it's also the effect on the whole area if, you have several buildings demolished, and as Dr. McEwen has actually phrased it to me a couple of times, it's kind of like teeth being pulled and there's a gap. So it's actually probably ideally better to have a continuous streetscape.
Yeah, but in terms of when we go back to 9364, we are talking about the heritage value of a particular building. That is actually contributing, whereas in the matters of expression, we are talking about that not the value of the building as in itself, but it's the value of the building to the greater area. Do I understand that right?
Indeed. Yes, you could read it. A is more about, well, I think very carefully about the effect on the area. B is more about what you said.
Okay.
I only really have a couple of questions. What I would like to have from you really is just so that I have a clear understanding of exactly how the consenting process would work in a situation where you have the double up, if you like, where it's in a character area and a heritage area, or in the in terms of Rugby Park, the underlying metropolitan zoning and the RHA overlay. Just want to make sure I understand how that would work in a consenting.
Probably two different questions in there. Firstly, the overlap between RHAs and character areas, and I think I pointed somewhere to a link to PC 14 situation on that. I can't quite see it, but yeah, we did provide a lot of information to the PC 14 panel about how that type of situation would be handled, and effectively it didn't end up looking like there was a huge problem, because we had before that aligned some of the built form rules, etc. Your second question was more about the open space zoning versus residential heritage area. And I think, as I said, I kind of almost took that for granted in the first case. But on reflection, there would probably be some things that we could do to improve that situation. And there are about three that spring to mind. One is we could ask Ian to be more explicit about buildings on Rugby Park and which ones have heritage value in their site record form. And probably as well as that, it could be possible to add an exception into that RD6 about new buildings with that exception. And I haven't got any wording yet. Be something around structures accessory to recreational activity being not pulled into the rule. I need to be clever already, and I wonder whether it might be something we might address in the right of reply.
Yes, I mean, it occurred when we stood there and looked around to that. Yeah.
I think the
there's quite a variety.
There is, and there's not that many sites other than open space sites where there's a collection of buildings on one site. Not that many sites like that in the RHAs. So it is a bit different to the norm. And in terms of heritage values, I don't know if we've fully evaluated each building, but for example, from my perspective as a non-heritage expert, I think the old grandstand might be something that we would want to continue to have in the RHA if they were wanting to demolish and rebuild that. But there are some other structures that, like the fence, that obviously we're not going to care about. And they already have things like the commentary box and such. So some of that's kind of more straight, functional, recreational. So I think we would need to think a bit carefully about how we would write such an exception. And the third option, of course, would be to exclude Rugby Park from the RHA, which at the moment I don't favour because I think it's got to blanket.
Yeah, we had some helpful discussion yesterday around the relevance of the park to the area,
Yes.
not only Rugby Park, but in combination with Melbourne. So you've heard that, so. Okay, presumably we're quite happy for you to explore that. There's thoughts, reflections on it, whether you land back where you started or with some possible changes, fine.
At this stage, I'm not sure whether we would have a written right of reply later or just.
It's very likely we will. I don't want to get all Mr. Pizzy's hopes up too early, but it's quite common.
Yeah, that is, thank you, that would be great, because I don't want to write something that
No,
just isn't.
I considered responsibility for the last
Yeah.
one, quite frankly.
Something up, but it's probably not a good idea. It'd be better to think through the
Yeah.
various definitions and think about it more carefully.
Let's write that out before we conclude things either today or tomorrow, but that would be helpful. I think.
And in terms of just the character areas, special character areas, it's both sets of rules applying if they're in an RHA as well.
Not rules now, but assessment.
Is that some of the conditions that could be covered off in the graphic that you asked for yesterday, if that was to include?
The wiring diagram, the wiring tree, whatever we're calling it, it's part of why I asked for that yesterday. I put that thought in your head is so it answers a lot of this. You're intimately aware of how this all interweaves. You've been doing it for a long time. It's a little bit harder for us to come up to speed on the fly sometimes as to how these interconnections work.
That's right. Well, the series of maps in 9379, which you might have as part of your package, actually shows the overlaps between the RHAs and character areas. And I did that early on in the piece in order to understand the situation.
Yeah.
You know, where
A pink line for character areas, we're going to read for the RHAs.
That's it. Yeah. There's about, I don't know, 5 or 6 of them. They've got overlaps with character areas.
Yeah, well, that spatial delineation identifies the areas where we've got the combo.
Yes.
And it's what I think the question was searching for, or how does that work to practice if you're able to fall within the situation of both from a consent point of view?
Yes, I should have said more clearly before that obviously if it's in a character area, it has to make the character area rules.
Yep.
RHA has to make the RHA rules. So there's 2 sets of rules.
Yes.
Which it's terrible. But I think it's administratively not that much harder than sort of a normal single area consent. If you look at the application cat in the reference somewhere, should be able to understand the scenarios that we examined.
We can do that.
Yeah, I thought I had a link to that part of the PC14 information package that we provided to that panel, where they asked us to go through various scenarios, and it wasn't me, but
Well, you don't have to, if it's not at your fingertips, that's fine. Just make sure we've got that.
yeah,
Yeah.
definitely. That was quite a question.
So it will be covered in the wiring diagram that you asked for yesterday.
If that's the easiest way to do it, or in a something.
Can you do
Which read.
But then are you asking me to do a wiring diagram for character areas as well?
No. No, but in the process of with the wiring diagram for RHAs, if you could add to that or somehow explain where there's the overlap, how do the two work in combination, or at least direct us to where that explanation exists.
Yes. It might be in the main.
But don't trouble yourself now. Obviously, we don't have the ability to influence the character of our provisions. Not part of the plan change today.
No.
But how that's rated.
I just have one more question for me, and it's in terms of Cranmer Square. And I understand this letter is sort of that being included in the RHA. Just from a planning perspective, heritage evidence on it, but from a planning perspective, is there any? Yeah, well, what's your view from a planning perspective on the square and with as being within the RHA?
We could do it, but I don't think that. Like the history of Greenmas here is potentially quite different to the history of the residential area to its south. Greenmas Square had a very early set of uses, including in relation to the schools, the old something normal school, might be post-church normal school, and the old girls' high site. They used to use it for recreational activity and such. So it's not, I don't believe, so intimately connected as some situations like the Rugby Park one. And Greenmas Square is scheduled anyway.
Thank you. Excellent. Thanks very much. It's very helpful. Sorry, sending for some homework. Again, thank you for accommodating us this morning.
Just before you do go, sorry. This has been produced to some idea as to what this has been provided. Was that from you or just some clear what this contains?
It was produced by Mrs. Richmond in relation to adding in what council was seeking as a submitter.
Okay,
My appendix B, which is the appendix to my evidence in chief, is the version of that chapter that doesn't have the council's.
right. Okay. No, that's helpful.
So otherwise, there's just the corporates, which we'll probably hear about shortly.
That's right. So that is the council position.
Yeah.
So it's got the council position adopting the evidence of Mr. Langman, all as and also council position in relation to Antonio Hill and Teesbury. So they're separately colour-coded in that document.
Okay.
So in that appendix B, my recommendations in the 42A are in purple.
Going back to it, every time I look at this, it's a rainbow of.
It was worse than that.
And as we're blessed.
So sorry, Commissioners, I would add to that, but this is only part 9.3, so the council position on the other chapters or other parts is as per Ms. Dixon said.
No, it's the other way around. It's the complete package that Suzanne put together, includes some minor amendments to other chapters, but mine only includes 1.3. Other than politics actually include definitions for RHAs, but other than
It's RHA specific.
RHA specific.
All right. Okay. Mr. Langman, I think is next on my schedule. Which kind of summary stuff?
So have you written out summaries or?
Right.
Yes, indeed.
Your heads?
Thank you, Commissioners. My name's Marcus Langman. I'm an independent planning consultant. I've set out my background on experience. I've prepared the evidence evaluating the remaining heritage-related submissions made 13 and 14, and I reaffirm that I am with the Environment Court's Code of Conduct for expert witnesses in presenting this summary. In relation to my evidence addressing heritage matters, I address the following matters. In terms of submission 1058, clarification to the application of the rules, addition of cross-references to Appendix 9372, which is the Schedule of Significant Historic Heritage for the listings for Linwood, Sydenham and Akaroa French cemeteries. Correction of names applying to heritage assessments for Akaroa. In relation to the clarification of the rules in submission point 1058.1, I recommend accepting in part with alternative drafting and consequential changes to other parts of the district plan. That's in the copy. It's Richmond, I understand is provided in terms of amendments. The addition of Spraden Lodge. In relation to 1058.2 and 1058.3 regarding the addition of the cemeteries, I recommend accepting the submissions. In relation to submission points 1058.4 and 1058.5, I recommend that the submission is accepted in part with a correction of the name to the Akaroa Design Review Panel. Just moving to submission 751, there are 6 points there. Amendments to Rule 8.9.2.1 P1 in relation to earthworks heritage item. The addition of Spraden Lodge to the Appendix 9.3.7.2, Schedule of Historic Heritage. Revision of the settings for 364, now 350 Rickerton Road, 20 Mona Vale Avenue, 106 and 10 Papanui Road and 29 Major Aitken Drive. Amendment to 2 sites in the Inner City West residential heritage area in relation to the site contributions mapping. Those are up 35 Worcester Street and 1 Armagh Street. Amendments to Appendix 9.3.7.4, which sets out the heritage item exemptions from various zone rules. An amendment of 9.3.4.1.3 RD1 to include a new provision that notes that where a building is in a heritage area but is not a heritage item, that the provisions RD6 of the same rule will apply instead. So in relation to the earthworks amendments sought through submission point 751.37, I recommend the submission is accepted in part with the correction to the text as outlined in my evidence. I recommend the scheduling of Spraden Lodge sought through accepted. In relation to the scheduling of heritage settings in submission point 751.40, I recommend the submissions are accepted, but with a further update to the settings of 350 Rickerton Road and 20 Mona Vale Avenue to reflect the subdivisions that have taken place since notification. So that's an amendment to the boundaries of those areas within the one thing I do note is that there was a mapping area that was made in relation to the graphic attached to my evidence, Appendix 2. Vale Avenue, and if you compare that to Appendix 1 of my summary statement, you'll see that Appendix 1 shows of my summary statement shows the boundary of the setting locking to the northern side of the access way, whereas in my evidence it looks to the other side. So it's just a correction of that. That's yeah. So that probably explains the remainder of that paragraph. In relation to requested changes to Appendix 9.3.7.4, heritage exemptions from zoning rules, as in the current submission. This is a slightly more complicated job in terms of exemptions. And what I recommend is that corrections are made by the hearing panel to the council to make amendments to the text principles set out in my evidence. The reason for that complication is the various status and the various operative status of plan change 14, which keeps changing on a regular basis. So what the solution that I've suggested is that, in my opinion, that can happen either by direction of the panel to council staff to supply an updated appendix that is accurate at the current date. So that could be for the right of reply, if any. Or alternatively, as part of the panel's recommendation to council in its decision, that the council updates the appendix as at the date of that decision. So relying on the principles that are set out in my evidence. So either option leaves the potential for further updates to the appendix being required when various parts of PC14 of the PC14 decision are made operative. These can be sort of for matters that occur after that decision. The council can consider whether it can take further changes for Schedule 1, Clause 20A, if their effect is minor. So those relate to exemptions from various zone provision rules, which set out things like exemptions from gross floor area, for example, for heritage buildings. The whole intention of the appendix is to make the reuse of heritage buildings easier without applying various particular rules from the various zone standards. So finally, I recommend that submission 751.47 relating to buildings that are in heritage areas and not heritage items, and the clarification of the application of Rule 9431, RD1 and RD6 is accepted, and there are no matters arising from other submitters' expert evidence that are relevant to my evidence. I think probably largely the amendment sought by the council and submission are administrative nature. So the purpose of them is to clarity around the drafting and ensure that the rules work properly together.
Yeah. What's the question?
I have one. On your page 8, can you please talk me through? You have in 9.3.4.1.3a under activities, middle of the page. The last sentence that is added there is rules for heritage areas do not apply to the Ekaroa Township heritage area. In your paragraph 25, the first sentence tells me the changes above are important to ensure that the items and settings rules apply within the Ekaroa heritage area.
Yes, that's because the rules that apply to scheduled items and settings still apply. If it was to say that, but not the heritage area rules themselves.
Okay, so so the difference is between the heritage area and the individual scheduled items.
That's correct, and they're covered by rules for the heritage area for Akaroa are covered by different provisions.
Thank you.
Thought on you offered us a couple of options here. I don't think we need to necessarily make a decision on those at the moment, but Mr. Pizzi, would mind your thoughts on those, or maybe.
Well, I think,
There's potential for things to change. Get that, we're moving. There's a number of things unresolved. They could be clearer, maybe resolved by the time a decision's made on PG13.
I guess if I might just comment that one happens later in time. So
Yeah, sure. Yeah.
So which has the benefit of potentially picking up subsequent changes as a result of various parts of PC14 coming off of it.
How difficult is this? Would it be?
I can assist for that as well.
I was asked to talk about this appendix. It is an absolute nightmare.
Yeah.
You may appreciate that it's something like 15 pages of rule references.
Yeah.
So the appendix is always in the state of flux, but obviously with PC14, particularly in the state of flux. So as soon as you try and get up to date, it's out of date again.
Yeah.
So in an ideal world, I would love to see it as more related to the principles of the types of exemptions that we're trying to apply. The problem with having rule references is that they it becomes very complex to administer, and it's very desperately trying to be really consistent and pick up every instance of the type of exemption. But that's like every single zone, and it's very easy to miss things. And so we're constantly having to try and revise it and keep it up to date. So it's almost impossible to keep it current.
I think as an example, I think between finished filing my evidence earlier this month and today, there's been parts of PC14, which is it's through administrative direction. So
I understand the issue. I'm just wondering whether there's any particular advantage with A or B of your two scenarios. My gut feel is there's probably not much necessity for urgency. You know what I mean, in terms of putting pressure on you around capturing as best you can or a state of the moment outcome and the right of reply. Leave it with us. We'll give you some directions on that, but that's my initial thought without having talked to my colleagues.
So in response to your question about whether I see any legal issues, and
yes.
no, I don't.
Yeah, either was a valid option.
They're both valid options, and as Mr. Langman says, one is later in time.
I'm just thinking of whether we're in our work got to be in any way disadvantaged by not having it until much later versus earlier. Haven't thought that through. Possibly not. And so therefore getting it close to accurate as and when a decision is made has some appeal. Intuitively, yeah. Okay. Thank you. Oh, sorry.
No, just briefly, and it's just from your planning perspective. Did you have were there any matters which the changes that have been suggested or the additions that gave you cause to think about scope?
Not really, because I think most of the issues that were dealt with were probably questions around reducing the amount of I guess restriction on activities.
The cemetery, the addition of that land that was left off at the entrance. Was it the Sydenham Cemetery? I can't recall which one it was.
That wasn't directly, so that related to I think the mapping of it. Not that's not addressed in my evidence.
Is it not?
No.
Oh,
Not that.
And you haven't commented on that.
Sorry, Mrs. Rickman.
Anything first?
thank you very much. Right. Oh, Dix, let's look at the next one. How are we going? We're at six minutes behind. It's very, very good. We'll take your submission now. Joll, if you want to come forward. Right, thank you very much. You know, look, where it suits you.
Is this okay?
You can say. We are a bit constrained, so. Once we read through. We're going to take through highlights of that. Do that, and then we'll have some questions, I'm sure. Just firstly, I don't think you were present yesterday. Have you had an opportunity to look at any of the material that's come forward from yesterday's?
I have done my utmost to listen in and see information when it's been available and things.
All right. You're here.
Koto Kautawa, my name is Joll, and I'm a partner at Plans Consultants Limited. My qualifications and experience outline paragraphs 1 to 5 of my evidence. My evidence this morning specifically addresses the merits of including alternative provisions to manage a discrete number of non-scheduled heritage items. Also consider the implications of the proposed amendments to the relevant heritage provisions. Starting with the proposed alternative provisions, for the reasons outlined in paragraphs 20 to 32 of my evidence, consider it is appropriate to provide alternative approaches to managing the discrete number of non-scheduled heritage items that remain vacant and badly damaged more than 14 years after the Canterbury earthquakes. It is my opinion that the alternative approaches sought by the submitter Ceres enables the district plan to more appropriately respond to known on-ground conditions and thereby better meet the Section 32 Resource Management Act tests, as opposed to the status quo and proposed provisions. With regard to the ability to identify buildings that could be included in the proposed schedule, Mr. Richmond states that the Council's heritage team is aware of the buildings which remain unrepaired and are included on the Council's earthquake-prone building register, and I have provided a footnote which references that. This information could be used as the initial basis for preparing the schedule. However, in turning my mind to heritage listed buildings that I am personally aware of that have been damaged and are currently in a state of disrepair or where repair and alternative works have not progressed or have stalled, I note the following: Victoria Mansions, which we can talk about in more detail as we've recently obtained resource consent to undertake works to that building. Although, as I think we're all aware, obtaining resource consent is really just the first in a number of hurdles before any development is actually implemented. the Peterborough Apartments, Inglefield Homestead on Fitzgerald Avenue, Stephen Taylor's Mistake Batches, Desbury House, Antonio, the Canterbury Provincial Chambers Building, New City Hotel, and the Library. It's probably at this moment I should make the panel aware I am currently involved in 4 different resource consent applications involving different works to heritage items. One for Christchurch City Council as asset owner in relation to the Little River Library, one for a demolition application for Christchurch City Council as asset owner in relation to a Taylor's Mistake badge. I'm also currently involved in a demolition application on the West Coast, and I am involved in an application for an adaptive reuse of a homestead out in Selwyn. So I'm seeing heritage at the coalface and how provisions and things work or do not work. If the panel would be agreeable, I'd be happy to work with the Council's heritage team to consider the makeup of the list, noting the acknowledgement of Council staff that they have a greater knowledge of those buildings and repaired and are included on the Council's earthquake prone buildings register than myself. In considering the appropriate activity status for the alternative approach being proposed, on reflection, it is my view that restricted discretionary activity status is more appropriate than controlled activity status, even in situations where a Section 124 building notice has been issued. Now, I think there's some confusion in the further submission that the submitted forward from Ceres, where they're seeking a controlled activity status. I should have been clearer in that further submission document. That was a subset of the schedule. So you'd have the schedule with RD status, but then a separate activity status if one of those buildings on that schedule were a Section 124 notice had been issued. As I said, on reflection, I think my thoughts on that were focused in on the example on the West Coast, and I sort of raised my eye line a little bit on that. I actually think restricted discretionary activity status is more appropriate. So even in situations where a 124 building, notice has been issued under the Building Act, I still think restricted discretionary is more appropriate activity status.
So you want us to take that as modified relief?
Yes, please.
So that's your obviously your expert opinion that you've just given us on reflection.
Yes,
You thought about those issues.
Said sometimes it's a get blinkers on, thinking of one particular project, and when you have a moment to step back and reflect, you realise the context is key. Turning to the second point, policy amendments, and as this process has progressed, this has, in my opinion, probably become the key issue for the submitter more than anything else. The changes to the policies or the provisions the council are proposing, and in particular that demolition policy. So as noted in paragraph 33 of my evidence, I have significant concerns with the proposed amendment sought by council, the operative policy 932-8. As a starting point, I know Ms. Richmond confirmed in response to panel questions yesterday that this policy has been working until now. As the council has not identified any problems with the operative wording as it applies to highly significant and significant buildings, and that she acknowledges that no Section 32AA evaluation has been undertaken on the proposed changes, I consider the additional amendments proposed by Ms. Richmond to this policy are not appropriate, and the requirements of Section 32AA have not been met. The proposed council wording now states that the demolition of a heritage item scheduled in Appendix 9372 is to be avoided wherever possible, particularly in the case of highly significant heritage items. I consider this to be a significant shift from the operative wording of when considering the appropriateness of the demolition of a heritage item scheduled in Appendix 9.2.7.2. The following wording, in my opinion, is more restrictive than the Section 6 direction to protect from inappropriate subdivision use and development. It is my opinion also that the proposed shift in wording is particularly problematic given the Section 104D threshold test for non-compliant activities. given that the effects, in my experience, loss of heritage that arise through the demolition of a heritage item would always be for the minor. And such as avoided wherever possible, in my opinion, is subjective. I consider applications to demolish even significantly damaged, highly significant heritage items, and I make the distinction with highly significant there because there is a difference in activity status in the district plan between highly significant buildings where it's non-compliant and significant where it's discretionary. So that's why I'm referencing highly significant there.
That's the relevance of 104D.
Specifically, yes. That are uneconomical to repair and reuse would in all likelihood have to be declined because of the requirements of Section 104D of the RMA, and in particular restrictions that are imposed for non-compliant activities. Concerns are further highlighted by the views of Ms. Richmond in paragraph 8.1.1.32 of the 42A report, in which she discusses the test for significantly compromised, which is referenced in policy 9322A2B. In summary, she states, where there is a repair strategy that would retain the significant heritage values of the building for which it is scheduled, then the test of significantly compromised is not met. So essentially, Council's position is that if an item can be repaired and retained, the values for which it is scheduled, this policy matter test that specific one is not met. My concern on the inclusion of the term avoid wherever possible is increased by the evidence of Ms. Richmond in Plan Change 14 in relation to the Blue Cottage, and referenced again through this process. I think Ms. Appleyard raised it yesterday as well, that owner-specific considerations are relevant, equally valid. And I think the example that was given yesterday by Ms. Appleyard was in relation to Blue Cottage, where Mr. Carter's personal circumstances were considered a valid matter in terms of whether or not he could afford to repair a building or not.
There are questions, I'm sure. Will we?
It's just, I guess what I'm wanting to explore with you is just what does that really, can you tell us a little bit about what's happened with Victoria Gardens and the consent agreement?
So essentially there's a consent for an adaptive reuse, alterations, and an additional basic story that's been added to that building. And the adaptive reuse is to create a 5-star hotel.
The whole building.
For the whole building, yes.
Was that procedure?
Resource consent's been granted. I don't think building consent has been launched.
Was that notified?
It was not notified, no.
And what? I mean, we've got an existing policy framework here, which it enables a number of matters to be taken into account, and in terms of the state building demolition and those sorts of matters. So, what does this add really to what is already in policy and the policy framework?
The changes to the policy, sir, or the second schedule?
What you're suggesting in terms of the scheduling of these. How does that, apart from perhaps activity status, obviously, but do you not consider that the policy framework at the moment, which enables these issues, expenses, etc., cost, reasonableness to be taken into account, do you not consider that's the most appropriate way of dealing with these buildings?
I think the operative provisions provided a pathway through for a variety of different works that the amended provisions no longer does. And I think as time has moved on, obviously the operative plan was developed in a recovery context. I consider we're still in a recovery context.
Put it crudely, but is the purpose of those provisions essentially to grant a license for the demolition of these buildings?
I don't think so at all, no. Still a resource consent process, still the ability for a council to decline that application if it isn't justified. So I don't think it signals these buildings for demolition. I think I state on my evidence what, if anything, in my opinion, would signal these buildings for demolition is the state of those buildings, the cost to repair those buildings, a variety of other factors. It's not the activity status in the flag that signals.
Can I just jump in and ask the discrete number? How much? What are we talking about?
I think it's somewhere probably in the 10 to 15 items.
10 to 15.
Yes.
How about other buildings? We only are concentrating on buildings that have been damaged by earthquake. There is a lot of other buildings that have been not damaged by earthquake necessarily, but have other reasons why they are in a very dilapidated state. Do they get a chance to, or?
Yes, I think they could, absolutely. And I reference the Taylor's mistake batches in that summary because some of that damage is not necessarily earthquake related. There's other factors there. There's geotechnical factors with rockfall hazards, etc. If, for example, fire could be a very valid issue as well. So it wouldn't have to be just earthquake damage. You could, for example, use for non-residential buildings, earthquake-prone buildings, so buildings that are less than 34% of the code as a starting point, cross-reference that with earthquake register and what heritage buildings are, and then with the assistance of council who has a great knowledge of heritage buildings that are potentially in a state of disrepair or are experiencing significant redevelopment challenges, then look to expand on the list from there.
What would your position be for buildings that have been there last however long and have actually naturally, in a way, come to a point where they are not really standing up?
There's a fascinating debate this actually. I know you guys have time frames and things, but there's no requirement to maintain a heritage building. Christchurch, as I talk about, and it's in a recovery context. So the buildings have been subjected to a significant natural hazard events. So in the particular Christchurch context, I don't think that matter of neglect is as obvious. And I say it's a fascinating matter because in the back of my mind, and I do digress here and I apologise for that, I wonder if we make consenting so challenging for heritage item owners and costly at times that they are reluctant to undertake the works And I think Christchurch is actually a really good example of where they have tried to provide provisions for maintenance and repairs as permitted activities to try and reduce those hurdles. But certainly in other areas, I do wonder if that is a contributing factor.
Thanks for that. Thank you.
I've got a couple of topics which I've got several questions about. The first is just scope, process, practicality of fulfilling the relief that you're seeking, which is reasonably generic at the moment. There's not a list of these buildings. There's no clear, to my mind, yet necessarily definition of what would qualify and what wouldn't.
Yes.
And so I'll come to that. And the second one is I want to explore with you a little bit more about your opinions around the challenges that Section 104D might present. So going back to you've given some suggestions of a possibility of what a list might comprise, or some that could be included. Clearly, that list doesn't exist. From a scope and process point of view, what's your perspective on our ability now to adopt this relief, evolve a list, and embody it in a decision? Do you have any thoughts around? I mean, perhaps the answer might lie in your perception of whether this degree of change is a greater level of restriction or lesser.
I think, well, I consider it's a lesser degree of restriction, and any property owner whose asset was included in the schedule has no obligation to utilise that provision. And by that I mean they don't have to apply to demolish as a restricted discretionary activity. They still have every opportunity to alter or amend or do any other
So we're only talking about the sphere of demolition.
Yes.
And what might confront them. The status doesn't change.
Well, the status would be.
Doesn't become more restrictive. The status would move from not compliant to discretionary. So less restriction.
Less restrictions, yes. Less consenting costs potentially, and
yeah, I'm just thinking with the scope lens. If that list was to be landed, what would be the defining? You've talked about a list that the council possesses and has knowledge of existing buildings. You've talked about some that are subject to already authorisations approved. What would be the criteria beyond those two things? What would qualify and what wouldn't?
I think as a starting point, it would be you could use buildings that for commercial or non-residential buildings that are less than 34% of the code. As a starting point, because they cannot be legally occupied.
As a starting point?
As a starting point, you could explore the earthquake register and cross-reference that to the list, to the heritage scheduling, I should say.
Yes.
Yes.
You understand what I'm saying?
Absolutely.
We don't propose solution complete.
Yes. If scope was the key concern, and I don't think this is the most efficient way forward, but we could simply restrict the sub-schedule to the Ceres buildings, the Victoria mansions and the Peterborough apartments. I personally think there are other asset owners out there that are in certain circumstances that should be ability to be on that same schedule and have their properties considered in a similar way. But if scope was a significant concern, then I think we could restrict it just to those two Ceres buildings.
Associated with that is obviously the Section 32 obligations on us. And without a full understanding detail of the buildings themselves or the circumstances of the buildings, what's your view from a planning perspective around that? Where does that position us? Is that an insurmountable view for following our Section 32 obligations?
I don't think so. I think this would be a more appropriate way to achieve the purpose of the Act. I think you're identifying a reasonably practical option for achieving an objective that is very much framed in a recovery on a recovery basis. Efficiency and effectiveness of those provisions, cost benefits. I don't see it as insurmountable though.
And would you think the information, notwithstanding we don't have a complete list yet, but what would be known about those buildings from the qualifying factors such as, earthquake, seismic risk, rating, that would be sufficient, do you think, to give us the information we might need to satisfy the Section 32AA response?
Yes, I think so, because
I'm not going to hold it.
because there's still a checks balance process because a recent sort of consent still needs to be going through. You still have to consider the matters in those policies and things, the matters of discretion and things that are identified.
Second matter was your 104D.
Yes.
I'll put it that way.
Yes.
And it hinges, the objectives are set, frankly, it's not changing.
That's correct.
So you've given us an opinion around the probable difficulty of having an effects threshold or gateway.
Yes.
Sensible. So in the realm of policies, an objective that is set and a policy that is your evidence possible of a change, not substantial substitution, but a tweak, if I could put it that way. Of wording.
Do I think a tweak would address the issues? No.
What I'm describing is what you've put as the alternative. And because what you're suggesting in your evidence is the proposed wording change or the wording avoid wherever possible creates a challenge around satisfying that 10D second gateway around this. Whereas your proposal would reduce that challenge, if not remove it.
That's correct.
Essentially what you're saying.
Yes.
And that hinges on whether avoided wherever possible versus we consider the appropriateness of the former wording, if you like, in the context of that policy is materially different. What is it about those two differences that would tip you thinking there's a high probability, if not a likelihood, of it being contrary to the policy with the wording wherever possible?
Yes. I think anytime.
So sorry, it's a very long-winded question, but
Yes,
I'm trying to tease out what is it about those two distinct differences of wording that flips from one to the other as being achievable versus probably not achievable in terms of that second gateway.
And a lot of it comes down to more recent case law and that use of the word avoid, which is essentially a thou shalt not pass. And you can try and quantify it by putting in phrases like wherever possible, but for me that's incredibly subjective. At the moment we have a policy that works. Council officers accept it works, and they're creating changes or suggesting changes that I think make it significantly less workable. And I don't think this policy gives effect as well to the objective that isn't changing as the operative policy does.
So again, I don't want to put words in your mouth, but the interpretation of, it's not avoided in every situation. There is an escape path there around what might be possible.
That's why I touch on my concerns regarding that, because if we start saying what's possible, and then I take you to Miss Richmond's statement where she says, if you can repair a building and it doesn't lose its reason for scheduling, then you haven't met where there is a repair strategy that will retain the significant heritage values of the building for which it is scheduled, and the test of significantly compromised is not met. So if I start working my way through the different matters and put a demolition hat on, and I come to, is there a threat to life and or property that interim protection measures would not remove? Well, in most instances, there are interim measures. I'm certainly haven't been involved in an application where there hasn't been an interim measure that could be applied. So we set that one aside. So then we come to whether the extent of the works required to retain and or repair the heritage building is of such a scale that the heritage values and integrity of the heritage item would be significantly compromised and the heritage item would no longer meet the criteria for scheduling. So again, I think you touched on it yesterday, Sarah, where you said there is almost always an option there. It's just whether or not, from a cost perspective, it stacks up.
I guess, yeah, I hear what you're saying. I don't want to labour this too much longer, but I guess in my mind, I'm trying to think of what would be the certainty that it would almost in every instance be contrary to that policy framework.
Yeah.
There's got to be some of those things that are present as options. Possibly the circumstances of every site will be different. Some may or may not be achievable. The fact that all are, does that automatically take you to a position of being contrary to the policy?
I think you would, yes, because I think if you work your way down this list, the only one that you can potentially look at is the matter of cost and reasonableness. And I know there's considerable time spent yesterday on this point.
Well, that very reasonable.
Yes. And I've sort of identified some of the concerns with council officers' opinion on what is reasonable and how that can, and the validity of that based on personal circumstances. So if I was to take that view of things and say you're a rich landowner, private owner, the cost for you to undertake that work is not unreasonable, and therefore that matter doesn't apply. And all of a sudden I am contrary to all the matters in that policy that can be considered. This is my concern. I don't.
Yeah.
I'm not
saying it would make that decision in every instance. There might be one in the past, but that's not necessarily precedent setting. Okay.
Again, I can't. Sorry to circle back here, but we have an acknowledgement that the current policy works. I don't think, and we're changing. We're making, well, the council seeking to make changes that make it less workable with no Section 32AA test being undertaken. I think that for me is the key consideration.
So I'm clear. So if the words would be possible were not included in that policy, you would be met.
Yes, that'll be, yeah. Yeah, I actually think the wording as adopted works perfectly fine. I've been involved, as I know you have too, sir, demolitions under that policy framework, and there is a pathway through. I'm not convinced that there would be a pathway through here, or certainly there is a risk, a far greater risk that the 104D could be an insurmountable hurdle.
It's probably a matter in terms of void means void. Probably not about we need to talk to you about, but one of the interesting in terms of that. Just busy given in light of the Otago and the northwest. Northwest.
That void doesn't always mean a void anymore.
Yeah. So I mean, it's been for years. So it's a, but there's.
Okay. Thank you.
Apologies, while Mr. Joll is still here, can I just make sure I've understood an answer to your question, Mr. Caldwell, and that was about, was it that it's your evidence, Mr. Joll? Look, I'm not sure, this is just to make sure I understood your answer. Was it your evidence that if the word avoid, with the change proposed by the council, if the word avoid was kept enough of this where possible, that's acceptable?
No, absolutely not. No, I think that would, if it was just a straight up.
Probably the opposite.
Yeah.
Right.
I don't think a void wherever possible needs to be there, full stop.
Okay.
I think if it was just a void, then you are absolutely go to stumble. every time at 104D.
Can I, one more question? Do you see that, however it comes out in terms of the appendix, the list, do you see that as a move piece, if you like, or would additions to that have to go through a plan change
I
process?
think additions would have to go through a plan change, to be honest. Yes,
So it's not a living document that would change.
unfortunately, no. I think you could have a provision that a building on the list, if it was no longer there, could be removed from that list, or but I don't think. I think it'd be challenging to continue to add buildings or items to that list without a plan change.
Right, thank you very much. Roughly around the morning tea break, I think. So, not sure who's going to speak. We might be appearing after morning tea. We've got quite a lineup. Papanui Heritage Group, etc. I don't know if they're representative of the groups. But let's take a 20-minute break. Let's take this. We take it 11 o'clock just before morning tea break. Thank you. whether that allows your person to arrive or not, follow up with you regardless. So let's give them a few more minutes anyways. Come forward.
Thank you.
See, I don't know how familiar you are with these processes at all.
I think with one or two court, but
You're not a novice. It's reasonably straightforward. Obviously, there's a submission in play.
Yes.
Do you have material that you want us to receive? You've got
I have provided this, and I know it's on the platform, all the
Okay.
information, so is that available to you?
we do everything that's on the website.
Okay.
Yep.
So all I want to do is talk to the main points.
Do you have written or printed material in relation to what you presented today that's new? Or
No, I don't.
Okay.
No,
That's fine.
no, it's no new material. And I'm not going to read it.
Appreciate that. All right. Well, if you want to speak to us, and then we may or may not have questions. Yeah, we'll see where we take it. In terms of your timing, how long do you think you might take?
Probably 10.
I don't want to constrain you much, but yeah. All right. Well, we're in your hands.
Thank you. Well, I do appreciate the opportunity. Obviously, I live in Papanui and I live in Wintermere Road, and we are aware of the heritage and the significance of the area that we live in. And the application we are making is that Windermere Road to amend Chapter 13 to include the significant heritage areas of the avenue, including the avenue effect, the housing trees and the parks. And we consider it should have protection analogous to Section 60 of Resource Management Act. And I'll come on to why later, but that's based on the previous IHP decision. That was a full IHP process. And
Sorry,
lots of evidence.
talking about the district plan independent hearings.
Yeah, the independent hearing panel in 2016 and their decision that they made in relation to avenues. So that was a thorough process. Obviously, our concern is that we don't want the War Memorial to have an end date of 2025. We want it to go on, and we want it to be looked after in an appropriate manner. So with regard to Windermere Road and the associated other 14 avenues, I've set out the history of that, the memorial streets and the original plantings and dates planted. It started in 1947, and the request was originally on 14 July 1943. And by 25 March 1946, there was a public meeting to further the project, and certain streets in the district were to be planted with trees as memorials to the fallen servicemen of the district. The focus, and I think this is quite important, was on side streets, not likely to carry arterial traffic. And by 20 August 1946, trees were planted in the 5 avenues. And by 13 May 1946, Windermere Road was being considered. There was no mention in those reports of reclining the memorial to trees, or consideration was given to the width of the road, the traffic density of the road, the minimum width of the footpath, and the focus street. The plants were added to the streets by way of public subscription, and the trees were planted with some contributions to be made by the costs of the residents. So it was a local memorial area. I did put in some overseas areas, not to say that we're on the same par with them at all, but just to see how in these times of lessened resources and heightened issues, how other countries were dealing with them. And the impact is that they are dealing with them by placing importance on them, and by preserving them, and by appreciating their aesthetic and cultural significance. I included some information on Moreton Bay and their avenue, and that has 760 trees. And the same theory though, it was £1 per tree planted post war, and it was seen as important for visitors to experience, and also seen as a significant memorial. There's other Australian tree memorials, and they were seen as a place of peace and tranquility. And also the English memorial avenues were also seen as part of the historic landscape.
And it was felt that historic and landscape interests had been undervalued at a national level and was now only being addressed. So the focus here in England is that historic landscape interest was had been undervalued and it needed increase. So we would suggest that the same focus ought to take place in this area, that these avenues perhaps have been undervalued at the national level, certainly perhaps the local level, and that they need to be addressed. In New Zealand, we have the Resource Management Act, and I've set out section 6 and the importance of that. Now, we have that leads to paragraph 12 with the Independent Hearing Panel decision in 2016, which considered at a full hearing the significance of Windermere Road in the context of a medium density housing issue. And they came to the view that there was potential historic heritage site under section 6F of the Act, and it would make it inappropriate for subdivision developments and development. I set out the quote in relation to Papanui South, which would be our area, and the view of the IHP chair at that stage was, frankly, if we had known this information, it would have been good reason not to require notification. This is because it at least indicates a potential matter of historic heritage to which the direction as to protection under 6F of the RMA could well apply. It sets out sort of a summary of the evidence, but specifically with Windermere Road, it says there are 4 streets, St James, Windermere, Dormer and Perry, that are war memorials that could be compared to Memorial Avenue itself. There are plaques recognising this status, and St James Avenue hosts the annual Anzac Day Parade, and as such, these streets have special significance, and we are satisfied the RMC zoning would denigrate that significance. And again, he talks about the importance of Windermere Road and those. He also talks about the issues of pepper spotting, which relates more to the high density issues that we're not really dealing with today. But the uptake of that was that it's an area of importance back in 2016, and it's an area that we continue to be valued. There was evidence provided in that hearing by Dr. Murray Williams, and he provided expert evidence as a member of the Papanui Heritage Group as to the nature of the housing in the area. And I note there were some comments by the council in the section 42 report, and it was where they were saying that some of the housing was not, was mixed, but he has confirmed that it was housing back to the 1880s and an eclectic mix of housing styles, some dating back to the late 20th century. He looked at some of the bungalows, in a particular villa at number 101 Windermere Road, probably built in the late 19th century, which he thought ought to be listed. And as a heritage expert, Dr. Williams talked about the importance of the war memorial and the uniqueness of the scope and nature of the scheme to Christchurch. And to him, he says it was an effective way to beautify the suburb, suggesting themes of reflection and regeneration. 4 streets of these, Dormer, Perry Street, St James Avenue and Windermere Road, are part of this memorial, and it's obvious the trees could fracture dead by the proposed changes in residential density. It is unlikely some of these trees could be removed to cater for access to smaller lots. So it is likely some of these trees could be removed to cater for access to smaller lots permitted under the rezoning. My opinion is this would occur, it would amount to a gesture of distributed respect in the war, and effectively demolishing the memorial. He says approving the recommendation would result in the eventual loss of built heritage created over a period of 130 years. This would negatively fracture the character of the areas of Papanui. So in terms of that, there is heritage within the housing stock. There is heritage within the character of the buildings that is consistent with the memorial status. It's an open and predominantly non-high density area at the moment. That memorial, to have a memorial, in my view, you need to have space to reflect and write, to be able to see the sky, to be able to have the sun come down on the trees, to have that memorial feeling that you would have in a park-like sort of setting. So I think Dr. Williams is important in saying that the housing stock is, with its heritage, which is consistent with the field, which is important for the memorials. I set out the intensification that has occurred in the area. We have Te Ora Health Educational Facility, which is going forward impressively, but it necessarily is a lot of population in our street there. We also have the Bellevue, which is a modern development. They've put in 4 wings now, and it has numerous occupants. I'm not sure of the exact number, but and they have staff and all the rest of it. So it's becoming a very, very busy area, and I would say a fragile area. And I don't want to talk about housing density because I understand that's not what we're here for today, but I do want to impact that we've already got that if that's going to be scheduled, particularly. So I would say that everything that can be done should be done to preserve the memorial aspect that we are left with. And it's not just the trees healthy. I mean, the trees do need to be healthy. They need to be protected from over parking. They need to be protected from development. They need to not have their roots dug up when someone's trying to put in a 6-story building. It all needs as much protection as it can have if it's going to survive. And I would hope that that would be seen as important and as part of our heritage, and that could be protected in this scheme. So I had concerns about the standard that the City Council had applied in their scheduled heritage place heritage assessment. They said it was a high cultural, spiritual significance, and they said the Papanui RSA expressed their value of memorials for the community. But the conclusion was that they would value the trees, and I think it has to go wider than that. It's not just the trees. You can have trees, but that's not a memorial. What they built Avenue, and they built a series of avenues from the cemetery through St. James Park, through to the St. James trees, and through the avenues with the specific trees relating to the areas of the battles. So it was a well thought out plan that stemmed right from the church where Charles Upham is buried, through the park, through the avenues, with that significance of the planting. And so to undermine one part of it or allow that to be eroded, in my view, would desecrate. So I have set out an extensive amount of information in my submission, which is primarily from the 2016 case, because I believe the information is still of value. The findings of Dr. Williams is still of value. The IHP decision, I believe, is still of value. That was a result of substantial hearing time and assessment by the then IHP chair. I've set out the Housing New Zealand development at that stage. They had no intention to develop in that area. But essentially the challenge for you is I would say it's worthwhile to protect this unique memorial. If they'd known, they should have built something else, but they didn't. They built Memorial Avenue with trees. So in the modern world, if you look at the international precedents, they're about valuing things. They're not about devaluing them. It is about mixing priorities, but I'd say if everything that can be done could be done to protect this valuable memorial, that would be wonderful. Thank you.
Thank you.
So just, you're referring to material in front of you. There's nothing in that material that you would add, that want us to receive, that would add to what's already been provided?
No, it's all paginated and filed.
Yeah, no, that's fine. So there's nothing further beyond. Yeah. Okay. But no, haven't taken anything out.
No, I haven't taken anything out. I believe it's all.
That's not a criticism.
No, I'd be very grateful if you could read it, and particularly the IHP decision from 2016, because they had no particular agenda about that. It was just an open discussion, and that chair himself with his own initiative came to the conclusion section 60 of the RMA. So that was their objective view, and I would ask you to consider that.
So your concerns are wider than just Windermere Street. Is that correct?
Well, I live in Windermere Road, and I'm concerned about Windermere Road, and I believe that Windermere Road and St. James Avenue are under extreme pressure because we have the high density on one side. St. James is all going to be high density. the other side of Windermere Road is going to be medium density. Some of the other avenues might have escaped that, but that's going to, St James Avenue and Windermere Road are pretty much sort of the foundation avenues for that memorial, because that's where it starts. Church on Hill Road, through the park, through St James, and then, passing through Windermere there. So those are really are the avenues that kick it all off, and those are going to be under extreme pressure as this develops through high density. So I would say there's a heightened risk, and it may be even then a greater onus to protect those than there would be in relation to the other avenues. But I'm sure the other avenues will also face pressure as time goes on.
Just in terms of timing, if you, and what came first, in terms of housing and the avenues?
Sorry, then the avenues were 1943, 46. Yep.
Yeah.
So there would have been housing there.
There was housing there.
Yeah.
And it's